Dear colleagues, ladies and gentlemen, my name is Anastasiadou. I am a research fellow at the British Institute of International and Comparative Law and a visiting lecturer at the University of Westminster. It is my pleasure, my absolute pleasure, to welcome you here today at the conference on the US and international law in changing times, very topical. It's organized by the SLS International Law section and Solon Solomon and Said Bagheri. It is a pleasure to see you all here today, and we hope that you will enjoy the interesting discussions that are due to take place over the course of the next 2 days. As you know, today's program includes two panel discussions, a keynote address by Professor Una Hathaway from Yale University, and a round table chaired by Professor Solomon. Tomorrow, the conference will continue at BUL, and it features additional panel discussions as well as keynote addresses by Professor Jose Alvarez and from New York University and Professor Gary Simpson from the London School of Economics. So we are truly in for a rich discussion and hopefully thought-provoking event. Before I pass the floor to Professor Solomon for his opening remarks, I would like to briefly introduce him. Solon is an associate professor at BUL Law School and author of The Justiciability of International Disputes. At BUL, he serves as co-head of the school's international law group and leads the school's YouTube series, the BUL Emerging Law Voices, where he has interviewed prominent figures from the legal, political, and media worlds, including the Director General of the Attorney General's Office and the former legal advisor to the UK mission to the United Nations, and the legal editors of The Guardian and The Times. In 2024, Solon produced a docudrama, Migrating Fears, which is now available on Amazon Prime. He has served in visiting positions in a number of academic institutions, including King's College University and the British Institute of International and Comparative Law. And he's currently co-convener of the International Law section at the Society of Legal Scholars of the United Kingdom and Ireland. So with no further ado, I would like to invite Professor Solomon to the podium. Thank you.
Thank you very much, Iris. Thank you very much for this brief introduction. Ladies and gentlemen, welcome to this international conference on the US and international law in changing times, a topic that is pertinent because we live in challenging and changing times. And the old era with the US dominating the world arena is maybe passed behind us. And we have to deliberate how we can accommodate our maneuvers, our moves in a multipolar world. On one hand, somebody could argue that this in multipolarity, the US are being prone to respect more international law instead of weakening it. In the sense that in times of instability and uncertainty, the US would have an interest to strengthen international law in order to bring forth stability and thus promote principles like the non-use of force, for example, in order to entrench its own interests all over the world. For example, the trade matters are matters that need a common language, and somebody could assume that at least when it comes to trade law, in essence, the US would have a more engaging stance vis-à-vis international law. It's a different question whether this engaging stance would be a stance on a multilateral level through the WTO or in a bilateral level through bilateral agreements between the US and the other countries. And of course, the tariffs wars, it's something that we're going to discuss also in the realms of this conference. But in essence, what's happening and what we see here when it comes to the US current stance vis-à-vis international law, we see a dual polarity, a bipolarity. And this bipolarity comes to the US attitude when it comes to other foreign third countries, and when it comes to the treatment of the US nationals on US soil, or when it comes to the treatment of international or international matters closer to the US borders. So, for example, when it comes to third countries, we see the US stepping forward in order to entrench peace and try to promote mediation and agreement between different states. We saw it in the Middle East in the case of the Abraham Accords. We saw it in the case of Armenia and Azerbaijan. We saw it recently in the cases of India and Pakistan and Cambodia and Thailand. On the other hand, as I said before, when it comes to how US even nationals are treated, even inside the United States, for example, migrants or even US nationals when it comes to issues of migration, when it comes to the drug war and how the US has taken an expansive rhetoric interpretation of the right to use of force even against drug dealers. And we saw recent incidents in the Caribbean and also recent episodes vis-a-vis Colombia or Venezuela. There we see that the US actually speaks more aggressively towards international law. So along these lines, the question is, which is the real way that international law reveals its facets vis-a-vis international law? On one hand, in essence, we can say that international law is being handled by the US currently on a more practical level. That means on a more business-like level. International relations are being seen as business transactions or business agreements. And of course, this has its pros and cons. But quite interestingly, in cases where these national interests of the United States are cited not in relation to foreign conflicts, the whole issue of having a business mind transaction becomes more problematic. I'm here and we're here in this conference to talk about existing legal norms, but to discuss the major question which has two facets: whether international law can be revisited and whether it should be actually revised. Now, by speaking about revision of international law, the fear is, as we can understand, as international lawyers, of course, we do not want this to happen, to destroy the whole building. But then the whole question we have to ask when we see, especially the current attitude of the US administration towards international law, if the intention is a priori to destroy international law or to try to realign it in order to serve American interests. Now, the idea that foreign policy and international law is drafted through the personality of the US leader, as is currently the case, is something that seems to be a step backwards when it comes to our conception about international law, our conception about law in general, in the sense that it was Max Weber, already in the 19th century, the political scientist, who spoke about the need for leadership to be based on bureaucracies and not on the personality of just a charismatic leader. But what we have seen the past few years, post-World War II, is an international community which is based on bureaucracy. And the question maybe we have to deliberate upon is whether it's too much based on bureaucracy. For example, we have the UN, and the UN with its many organs, and politicization attempts and politicization arguments have entrenched sometimes the functioning of these organs. For example, we have the International Court of Justice, which is essential for the entrenchment of international order. But at the same time, it has certain shortcomings, which have been pointed out by us, by international lawyers, but not much has been done so far in order to address them. And I'm talking in concreto about, for example, how evidence is being assessed before the International Court of Justice, and the fact that we have matters of expertise, like environmental matters. Nowadays, you have urban warfare, and the International Court of Justice, although through its statute, legally, it has the opportunity to resort to experts orally, it doesn't do so, and just relies on experts' opinions, on UN officials who have penned certain opinions. And again, these UN officials are appointed by the UN Human Rights Council many times, which on its own is sometimes maybe plausibly accused of politicization. So it seems that international order sometimes enters a vicious circle. And unless we are ready to introspect in order not to destroy, but in order to reinvent maybe international law, then the fear lurks that populism will rise because politicians will very easily come to just refuse our arguments. Another example I will give you before I shortly conclude this short intervention and opening words of mine. For example, we have nowadays the whole discussion about the right to self-determination. The right to self-determination, which is essential to exist, it's meant to protect the weak populations, the weak ethnicities, which deserve also a state. But at the same time, whereas in the 60s and the 70s, the right to self-determination was automatically interpreted as a legal independence, we see by practice, and here I refer not only to US practice, but practice also by other states. And quite interestingly, we have recently also a UN Security Council resolution in the case of Western Sahara, Resolution 2797, that was adopted now, only some days ago. And it speaks about granting autonomy in Western Sahara instead of independence under the Moroccan framework. Somebody could argue this is an exception, this is a violation of international law. But at the same time, we see other state initiatives to equally address self-determination claims in other cases. For example, we have, again, some months ago, the agreement between New Caledonia and France. The agreement that, again, didn't grant independence to New Caledonia, although the New Caledonian actually expressed an interest to become independent. We have, and since we're here in a conference about the US and international law, the whole plea of the US president when he entered office to annex Greenland. And of course, this is something that negates international law, but at the time it's quite interesting that the Greenlanders themselves didn't immediately oppose. After some days it did happen, but the immediate reaction was not an opposition, and they were ready maybe to just discuss, instead of being independent, to belong as an autonomy region instead of Denmark to the US. So we see in these days that there is some flexibility, at least from part of some states, and not only the US, to reshape international norms. Again, there is possibility of us as international lawyers, not necessarily to sanction or necessarily to uprightly refuse such a scenario, but to debate it, to examine it, and to responsibly bring forth our stance and understand the evolution of international law. Unless we understand that international law is dynamic, then the fear lurks that we, international lawyers, will remain to be irrelevant maybe to the developments in the international arena. And this will be a very bad development for international law, for international peace, and of course for us, international lawyers. Ladies and gentlemen, I welcome you again to this conference, and I hope you have an interesting discussion and debate. Thank you very much.